Welcome, future legal minds. This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And this is episode 12 of Torts. Today, we're kicking off our look at negligence with part 1, duty of care.
Yeah, duty. It's where it all begins.
Now, just so you know, we are AI bots. We've been brought to life by, well, the magic of AI and Angela's really comprehensive IIED and negligence notes.
That's right. Angela's actually hitting the books hard for the bar exam right now, so we're stepping in to help you navigate these concepts using her materials.
Her notes are pretty amazing, actually. They're the backbone of this whole podcast.
Definitely. Our goal here is to give you a really clear, solid understanding of duty of care. It's like the absolute foundation for any negligence claim.
And we're using Angela's detailed law school notes to guide us. We're not just aiming for you to memorize rules.
No, not at all. We want you to get the why behind it, the how it works. So these ideas actually stick with you, beyond just the exam.
Exactly.
Yeah.
Now, speaking of Angela, if you happen to need to contact her about the podcast or maybe her notes, you can shoot her an email. It's podcast@studyforthebarinyourcar.com.
And it's worth mentioning she also works as a freelance law clerk. Does really great work.
Oh, absolutely. So if you are an attorney or maybe you know one who needs some ad hoc help, things like legal research, drafting motions, complaints, writs, answers, briefs, that sort of thing.
Yeah, any of that stuff. She's really good. You can reach her for professional services at hello@legalwriterandlawclerk.com.
Seriously, the quality of these notes we're using today just shows how thorough she is. Okay, let's dive in.
All right. Negligence. Big topic. At its heart, every single negligence claim needs 4 things. Think of them like legs on a table.
Got to have all 4 or the whole thing collapses.
Exactly, they are. Duty, breach, proximate cause, and damages. Duty, breach, proximate cause, damages.
And you, the plaintiff, you have to prove every single one of those elements to win your case.
Right. It's like building something, you can't skip a step. And the very first step, the absolute foundation, is duty.
That's our focus for this entire podcast. Duty. Because without a legally recognized duty, well, there's just no case, is there, no matter how bad the injury?
Nope. No duty, no negligence claim. End of story. So the big question we need to tackle is, what is duty in the world of tort law?
It's not just like a moral feeling that you should do something. It's a legal requirement.
Precisely. It's a legal obligation. It answers the question, to whom do you owe a standard of care? And under what circumstances? It kind of draws the line for legal responsibility.
Okay, so let's start with the general duty of care in negligence. What's the basic rule?
Well, Angela's notes lay out a really core principle, especially important in this Commonwealth. When you're talking negligence, particularly with things that are, potentially dangerous.
Like tools or machinery or chemicals.
Yeah, exactly. There's really only one standard of care. Just one. And that standard is reasonable care.
Okay, reasonable care. But wait, only one standard? That seems odd. Doesn't the level of danger matter? Like, surely handling gasoline requires more care than handling, a box of tissues.
That's a really common point of confusion and a great question. It feels like the standard itself should change, right?
Yeah, like a higher standard for dangerous stuff.
Well, Angela's notes clarify this using the restatement of torts. It says basically, the care required is always reasonable care. The standard never varies.
Never varies. Still sounds weird, but...
And here's the key part. The care which is reasonable to require of the actor varies with the danger involved in his act and is proportionate to it. The greater the danger, the greater the care which must be exercised.
Okay. So the label reasonable care stays the same, but what that actually means in practice gets way more demanding depending on the risk.
Exactly. It's about proportionality. The standard is constant be reasonable. But the amount of care, the degree of caution needed to be reasonable, scales up dramatically with the danger.
So handling gasoline does require, let's say, a higher degree of care. But that's just what reasonable care looks like when handling gasoline. It's not a fundamentally different legal standard, just more demanding actions within that standard.
You got it. It's about the conduct required under the circumstances, not a separate tier of duty. Angela's notes mention a case, Conchar v. Sebula, that reinforced this. It said, references to a higher duty just mean exercising more care, not some totally separate extraordinary care standard above reasonable care.
Okay, that makes more sense. It's a flexible standard applied consistently. So let's nail down this baseline, the reasonably prudent person. This is our yardstick, right?
It is. This is the objective standard we use to judge conduct in most negligence cases. Keyword,
Objective.
meaning we don't care what the defendant personally thought was careful, or if they were having a bad day or just aren't very bright. Generally, no. The law asks, what would a hypothetical, average, reasonably prudent person, someone with ordinary intelligence and judgment, have done in their exact same circumstances? Mental shortcomings, like maybe a lower IQ or poor judgment, usually don't change that objective standard.
But there are some exceptions or adjustments. Angela's notes mentioned a couple. What about someone with special skills?
Good point. Yes. If someone has superior skill or knowledge, maybe they're a trained professional like a doctor or even just someone known to be an expert driver or swimmer, they're expected to use that superior skill or knowledge.
So they get judged against a reasonably prudent person with that same skill.
Exactly. The standard rises to meet their enhanced abilities.
What about physical characteristics? Like if the defendant is blind, we don't judge them against a sighted person, surely.
Right. The law does take relevant physical characteristics into account. Blindness, deafness, maybe a physical disability. The standard becomes what a reasonably prudent person with that same physical characteristic would do.
So a reasonably prudent blind person, using maybe a cane or a guide dog, exercising caution appropriate for their condition.
Correct. But remember, this generally applies to physical characteristics. As we said, mental characteristics, low intelligence, excitability, mental illness are typically not factored into the objective, reasonable person standard. It's a somewhat controversial area, but that's the general rule.
Okay, objective standard, with exceptions for superior skills and relevant physical traits, but usually not mental ones. Got it. Now, this is a big one. Duty is only owed to foreseeable plaintiffs. This feels crucial.
Oh, it is absolutely crucial. This principle basically limits who can sue. You don't owe a duty to absolutely everyone in the world for every action you take.
Only those you could reasonably foresee might be harmed by your actions.
That's the core idea, often called the zone of danger. If someone is outside that reasonably foreseeable zone of risk created by your conduct, then generally you don't owe them a duty, even if they somehow get injured as a result of your actions.
And this brings us to the case, right? The one everyone studies. Palsgraf.
Palsgraf v. Long Island Railroad, 1928. Yep, the classic. Angela's notes naturally cover it in detail. It really cemented this whole foreseeability requirement.
Okay, set the scene for us. What happened in Palsgraf? The facts are kind of wild.
They really are. Picture this. August 1924. A busy train platform in Brooklyn. Helen Palsgraf is there, waiting for her train with her daughters.
Just an ordinary person waiting for a train.
Right. Then, as a train starts moving, two guys run to catch it. One is carrying a package. A platform guard pushes him from behind. A train crew member pulls him from inside. They're trying to help him board the moving train.
Sounds chaotic.
Yeah.
And probably not the safest procedure.
Definitely not. In the midst of this scramble, the guy drops the package onto the tracks. And then, boom, it explodes. Turns out it was full of fireworks. Nobody knew that just by looking at it.
Fireworks. Wow. Okay, so there's an explosion. But Palsgraf wasn't right next to it, was she?
No, that's key. She was quite a distance away. The notes say maybe 10 feet or more from where the package exploded. But the force of the blast, or maybe the panic it caused in the crowd.
Yeah.
What happened? It knocked over a heavy coin-operated scale on the platform. And tragically, the scale fell right onto Helen Palsgraf.
Oh, wow. So she was injured by the falling scale, which was knocked over by the explosion from the dropped package.
Yeah.
It's quite a chain of events.
Exactly. She suffered shock, bruising, and developed a bad stammer afterwards, which her doctor linked to the trauma, so she sued the railroad.
Claiming the railroad employees were negligent in helping the guy board, which led to her injury. And she won it first, right?
She did. The jury gave her $6,000. The railroad appealed, the verdict was affirmed, but then they appealed again to New York's highest court.
And that's where Judge Cardozo comes in, the famous majority opinion.
Chief Judge Cardozo, yes. In a close 4-3 decision, he wrote for the majority, overturning the verdict. His reasoning is the core of the foreseeability rule.
What did he say? Why wasn't the railroad liable to her?
Cardozo essentially said, the railroad employees might have been negligent towards the man carrying the package, maybe even towards the package itself, but they breached no duty to Helen Palsgraf. Because injury to her was not a foreseeable consequence of helping a man board a train with an ordinary-looking package. There was nothing about the situation to suggest that their actions posed a risk to someone standing way down the platform.
So even if their actions were negligent towards the guy with the package, that negligence didn't transfer to Palsgraf because she wasn't someone they could reasonably expect to harm. She was outside the zone of danger created by their specific act.
Precisely. Cardozo framed it as negligence in the air, so to speak, will not do. The conduct has to create a foreseeable risk of harm to the particular plaintiff or to a class of persons to which the plaintiff belongs. Since injury to Palsgraf wasn't foreseeable from the act of pushing the passenger, the railroad owed her no duty regarding that act.
The harm was too remote, too unexpected.
Right. A bizarre, unforeseeable consequence. So no duty, no liability. That's the Cardozo view, the majority rule.
But it was a split decision. Judge Andrews wrote a famous dissent, didn't he? He had a very different take.
He did. Judge Andrews argued for a much broader view of duty. He basically said, if your negligent act creates any risk of harm to anyone, then you owe duty to everyone injured as a proximate result of that act.
So his focus was less on who was foreseeable and more on the chain of causation from the negligent act.
Exactly. Andrews thought if the act was negligent, like carelessly pushing the passenger, then anyone injured as a natural and continuous sequence of that act should be able to recover as long as the causation link is there. Foreseeability of the specific plaintiff wasn't the key for him. It was more about the directness of the causal chain.
It's really a fundamental disagreement about how far legal responsibility should extend. Cardozo draws a line based on foreseeable plaintiffs. Andrews draws it based more on direct causation from the negligent act.
And that tension, that policy debate, still exists in tort law today. Most jurisdictions follow Cardozo's foreseeable plaintiff zone of danger approach, but Andrews' dissent is always discussed because it raises important questions about fairness and the scope of liability.
Fascinating stuff. Okay, let's move on from the general principles in Palsgraf to some specific types of defendants who have special duty rules. First up, children.
Right. Kids are different. The law recognizes they don't have the same judgment or capacity as adults.
So we don't hold them to the reasonably prudent adult standard.
Generally, no. The standard for children is mostly subjective. They're held to the standard of care of a reasonably careful child of similar age, intelligence, and experience.
So you compare a 7-year-old defendant to other reasonable 7-year-olds with similar backgrounds and smarts.
Pretty much. It acknowledges their developmental stage. It's usually a more lenient standard.
But Angela's notes mention a big exception, the adult activity rule.
Ah, yes, very important exception. If a child engages in an activity that is inherently dangerous and normally only undertaken by adults.
Like driving a car. Or a motorboat, as her notes mention.
Exactly. Driving cars, motorboats, maybe even things like operating heavy machinery. In those situations, the child is typically held to the same standard of care as a reasonable adult performing that activity.
Wow, so the leniency disappears. Even if the child is, say, young or inexperienced or has a learning disability.
That's the general rule for adult activities. Angela's notes give a stark example. A 13-year-old with a low IQ driving a car hits someone. Because driving is an adult activity, he's held to the adult standard, and his lack of experience or mental disability likely won't excuse him. Public safety concerns tend to override the usual subjective standard here.
That's quite strict. What about when kids violate statutes, like jaywalking or riding a bike wrong? Is that negligence per se for them, like it might be for an adult?
Usually not automatic negligence per se. Angela's notes cite a case, Bowman v. Crawford, which said a minor's violation of a statute isn't proof of negligence per se itself.
So it doesn't automatically mean they were negligent.
Right. It can be introduced as evidence of negligence, evidence that they might have breached the duty of care expected of a child their age, intelligence, and experience. But it's not conclusive like it often is for adults, especially when the activity is considered a typical childish activity.
Makes sense. Okay, moving from kids to the other end of the spectrum. Professionals. Doctors, lawyers, architects, accountants.
Right. Their standard of care is definitely not the basic reasonable person. It's elevated.
How is it defined?
Professionals are generally held to the standard of care of an average member of their profession, practicing in good standing within a similar community. It's about possessing and exercising the knowledge and skill commonly held by members of that profession.
So you compare a doctor's actions to what other competent doctors in a similar situation would do, not just any random person.
Exactly. And to prove professional negligence or malpractice, the plaintiff typically has to do two things. First, establish what that specific professional standard of care is for that situation. Second, show that the defendant professional's conduct fell below that standard.
And this is where experts usually come in, right? Because how would a jury know the standard of care for, say, brain surgery?
Precisely. Angela's notes stress this. Expert testimony is almost always required. You need another professional from the same field to explain to the jury what the standard practice is and how the defendant deviated from it. As the notes say, the jury doesn't know what is reasonable for that profession.
What about specialists? Like a cardiologist versus a general practitioner. Is the standard different?
Yes. Specialists are held to an even higher standard, often a national standard.
National, not just similar community.
Correct. If a doctor holds themselves out as, say, a board-certified specialist in orthopedics, Angela's notes say they're compared to other orthopedic specialists across the country. The idea is that specialized fields have more uniform national standards of practice.
And if the plaintiff doesn't bring in expert testimony showing the specialist breached that national standard,
Then the case might get dismissed. A directed verdict for the defendant is common if the plaintiff fails to establish the standard of care and breach through proper expert evidence.
okay. Beyond general competence, there's also a specific duty for doctors about disclosing risks, isn't there? Informed consent.
Absolutely critical. Doctors have a duty to inform patients about the material risks associated with a proposed treatment or procedure so the patient can make an informed decision. Failure to do so can be a separate basis for liability.
What about drug risks? Angela's notes mention something called the learned intermediary doctrine.
Right. This usually applies to prescription drugs. The general rule is that the drug manufacturer satisfies its duty to warn by warning the prescribing doctor about the drug's risks and side effects.
Not the patient directly.
Typically not. The doctor is the learned intermediary who is expected to understand the complex information and convey the relevant risks to the patient based on their specific situation. So if the manufacturer warns the doctor and the doctor doesn't warn the patient's claim is usually against the doctor for failing to inform, not the manufacturer.
Unless the manufacturer advertises directly to consumers, like those TV ads.
That's a potential exception. If the manufacturer engages in heavy direct-to-consumer advertising, some courts might find they've undertaken a duty to warn the consumer directly as well. But the default is the learned intermediary rule.
Okay, that clarifies the professional duties. Now, let's get into the really intricate area. Duties owed by possessors of land. This seems to have a lot of categories.
It does. Your duty as a landowner or occupier depends heavily on the status of the person entering your property. We start at the bottom row. Unknown trespassers.
People you don't even know are on your land.
Right. And Angela's notes are blunt here. Undiscovered trespassers are never owed a duty of care no matter how they were injured. You generally have no duty to make your land safe for people whose presence you are completely unaware of.
No duty to inspect, no duty to warn, nothing.
Pretty much nothing regarding conditions on the land. There's maybe a very narrow exception for, intentionally setting a trap, but for ordinary negligence regarding land conditions, no duty to unknown trespassers. An owner isn't liable if a hiker they didn't know about gets hurt by a falling dead tree branch on their remote property.
Okay. But what if you do know, or should anticipate, that trespassers are coming onto a specific part of your land, like a path everyone uses as a shortcut? These are known or anticipated trespassers.
Right. If you know or have reason to know that people constantly trespass on a limited area of your property, then a very limited duty arises.
What is that duty?
It's primarily a duty to warn them about or make safe any artificial conditions on the land that the possessor knows about that the trespasser is unlikely to discover and that pose a risk of death or serious bodily harm.
Artificial conditions, like what?
Yeah,
Not just a natural ditch.
Generally artificial. Think high voltage wires, an open mine shaft, maybe some dangerous machinery left out near the known path. And it has to be something the trespasser probably won't notice. Also, you have a duty to carry out your activities on the property with reasonable care if you know trespassers are present.
So, still a pretty limited duty, focused on known, hidden, man-made death traps, basically.
That's a fair summary. It's more than for unknown trespassers, but much less than for people you invite.
Okay, next level up. Licensees. Who are they?
Licensees are people who are on the land with the possessor's permission, but they're there for their own purpose or benefit, not the possessor's. The classic example is a social guest, friends visiting your house.
Or maybe someone like a door-to-door salesperson you let talk to you.
Exactly. They have permission, but they're pursuing their own agenda.
So what duty do you owe your dinner guests, your licensees?
You owe them a duty regarding hazardous conditions that meet two criteria. One, the condition is concealed, not open and obvious, and two, the possessor knows about it in advance.
So you have to warn them about that tricky loose step you know about, but you don't have to, inspect your whole house for hidden dangers before they arrive.
Correct. There's generally no duty to inspect for unknown dangers for licensees, and no duty to repair known dangers. The main duty is to warn them about known, hidden dangers. You also have to conduct any active operations on the property reasonably.
Like, don't carelessly swing a golf club in the backyard while they're walking by.
Right. Warn of known hidden dangers and act reasonably during active operations. That's the core duty to licensees.
Okay, top tier then. Invitees. These get the most protection.
They do. Invitees are people who enter the land either for a purpose connected to the possessor's business, like customers in a store, patients in a clinic, or because the land is held open to the public for that purpose, like visiting a public park or museum.
People you invite on for your benefit, essentially, or because it's a public space.
Pretty much. And because they're there for the possessor's potential benefit or as part of the public purpose, the duty is higher.
What does that higher duty involve?
The possessor owes invitees a duty regarding hazardous conditions that they either know about or could have discovered through reasonable inspection.
Ah, so there is a duty to inspect for invitees. That's the big difference from licensees.
That's a major difference, the duty to inspect. And once a hazard is known or reasonably discoverable, the possessor must either fix it, make it safe, or provide an adequate warning.
So a store owner needs to reasonably check for spills, fix them, or put up a wet floor sign. They could just ignore potential dangers.
Exactly. Angela's notes mention an example where a store might be liable for a malfunctioning automatic door under res ipsa loquitur. The idea being the malfunction itself suggests negligence because the door is under the store's exclusive control and maintenance.
What if an invitee goes somewhere they aren't supposed to? Like a customer wandering into the employees-only stockroom. Do they keep invitee status?
Generally, no. If an invitee exceeds the scope of their invitation, goes beyond where they're permitted or expected to be, they typically lose their invitee status and become, at best, a licensee or maybe even a trespasser.
So the duty owed drops significantly.
Right. Unless, as Angela's notes point out, they were expressly or implicitly invited into that restricted area by the possessor. If an employee says, "Come back here with me," then the invitee status and the corresponding duty usually extends to that area.
Makes sense. Now back to trespassers, but a special kind. Trespassing children. This involves the attractive nuisance doctrine, right?
Yes, a very important doctrine. It recognizes that children, due to their age and curiosity, might be drawn to dangerous conditions on property and may not appreciate the risks involved.
So even if they're technically trespassing, the landowner might still owe them a duty.
They might add a duty of reasonable care, yes, but only if several specific conditions are met. It's a 5-part test, basically.
Okay, what are the conditions?
First, the owner knows or should know children are likely to trespass in that area. Second, the owner knows or should know the condition poses an unreasonable risk of serious harm or death to children. Third, the children, because of their youth, don't discover the condition or don't realize the risk involved.
So the child's lack of understanding is key.
Very key. Fourth, the utility to the owner of maintaining the condition in its dangerous form and the burden of eliminating the danger are slight compared to the risk to the children. Basically, is it easy to fix?
And fifth.
Fifth, the owner fails to exercise reasonable care to eliminate the danger or otherwise protect the children, like putting up a fence or warning signs.
So it's not just anything that attracts a child. It has to be a known danger in a place kids are likely to be, where the kid doesn't get the risk, and it's relatively easy for the owner to make safer, but they don't.
That's a good summary. Angela's notes emphasize that you need evidence the possessor had reason to know kids were likely to trespass, and evidence the specific child plaintiff didn't appreciate the risk. It's not automatic just because a child got hurt in someone's property.
Right. What about recreational land users, like parks or trails? Angela's notes mentioned Rule 1715.
Yeah, that seemed to relate to comparative negligence. The note suggested that even a child, maybe a bright 9-year-old, might not recover if they fail to appreciate an obvious risk, especially if there was also a warning sign. It implies that even with land open for recreation, users, even kids depending on age and obviousness, bear some responsibility for avoiding clear dangers. Their own negligence can reduce or bar recovery.
Okay. And duties to people off the premises. The example was about a landlord and a tenant's vicious dog.
Right. The key takeaway there seemed to be landlord knowledge. If the landlord knew the tenant's dog was dangerous when they leased the property or renewed the lease, they could be liable if that dog bites someone off the property. But if the landlord had no notice, no reason to know, then generally no liability.
So it ties back to the landlord's ability to control the risk through the lease.
Seems like it. Knowledge triggers a duty.
What about other landlord-tenant duties? Angela's notes had a few points, like Landlords usually can't sue sublessees directly.
Correct. Due to lack of privity, the landlord's contract is with the original tenant. Also, the note about legal possession versus actual possession under the American view, the landlord mainly needs to provide the right to possess, not necessarily kick out a holdover tenant for the new one. And the point about retaliatory eviction, landlords can't typically evict just because a tenant asserted their right to a habitable place.
And the falling chair example. Landlord's not liable if it wasn't under their exclusive control.
Yeah, if a hotel guest throws a chair out the window, the hotel might not be liable because the guest had partial control, breaking the hotel's exclusive control needed for some liability theories.
Lastly, under land duties. Vendors of realty, people selling houses.
Yes. The key point from Angela's notes is that a seller can be liable for negligence if they knew about a dangerous defect, sold the house anyway without disclosing or fixing it, and someone later gets injured by that defect. You can't just knowingly pass off a dangerous condition.
Okay, that covers a lot of ground on land possessor duties. Let's shift to some other special duty situations. Rescuers first.
The rescue doctrine. It's generally seen as favorable to rescuers. If a defendant's negligence creates a dangerous situation and someone else gets injured while reasonably trying to rescue a person endangered by that situation.
The original negligent defendant is liable for the rescuer's injuries too.
Usually, yes.
Hmm.
Because rescue attempts are considered a foreseeable consequence of creating peril. Danger invites rescue, as the saying goes.
But there's a catch. The rescuer can't sue if the person they were rescuing wasn't actually put in danger by the defendant's negligence.
Right. If the defendant wasn't negligent in the first place towards the person being rescued, they generally aren't liable to the rescuer either. The rescuer's claim depends on the defendant's initial tortious conduct.
Okay. What about professional rescuers, firefighters, police officers? There's the firefighter's rule.
Yeah, this rule generally limits recovery for them. The basic idea is that firefighters and police officers are barred from suing for injuries caused by the very negligence that required their presence in the first place.
Why? Because that's the job they signed up for.
Essentially, yes. Risk assumption is inherent in their profession, and they're compensated through salary, benefits, disability programs for taking on those risks. Allowing them to sue for injuries from ordinary negligence that creates the need for their services would place a heavy burden on the public.
But Angela's notes mention an exception, something about non-emergency situations or risks not inherent to the job.
Exactly. The rule might not apply if the injury occurs in a non-emergency context or results from a risk unrelated to the specific dangers associated with firefighting or policing, like the example of an officer slipping on ice at the station that's usually not considered an inherent risk of police work covered by the rule. So it's not an absolute bar in all circumstances.
Got it. And then prenatal injuries, a very sensitive area.
Extremely. Angela's notes focused on wrongful birth actions. These are claims by parents.
What are they claiming?
They claim that negligent advice or treatment by a defendant, usually a medical professional, deprived them of the choice to avoid conception or terminate a pregnancy, leading to the birth of a child with significant defects.
And what damages can they recover?
Typically, they can recover the additional extraordinary costs associated with raising a child with that specific disability or condition, things like special medical care, therapy, equipment, specialized education. But crucially, they generally cannot recover the entire cost of raising the child. The focus is on the extra expenses caused by the negligently undiagnosed condition.
So compensation for the financial burden resulting from the negligence, not for the existence of the child itself.
That's the usual approach, yes. It's a very complex and often emotionally charged area of law.
Definitely. Okay, final major topic on duty. Statutory standards or negligence per se. How does violating a law affect the duty of care?
This is a way the standard of care can be set by a legislature, rather than just the common law reasonable person standard. But it's important to distinguish it from statutes that just create a civil lawsuit directly.
Right. Some laws explicitly say if you do X, you can be sued for damages, like maybe an environmental law or a dog bite statute.
Exactly. In those cases, the court just applies the statute. Negligence per se is different. It applies when you have a statute, often a criminal or safety statute, that doesn't say anything about civil lawsuits.
It's like a speed limit law, or maybe a building code requirement.
Perfect examples. The statute just sets a standard of conduct and maybe imposes a fine or penalty for violation. Negligence per se is a common law doctrine where courts basically say, okay, the legislature has set a minimum standard of conduct here. If you violate that standard without excuse and cause the type of harm the statute was designed to prevent, to someone the statute was designed to protect, then you've breached your duty of care. You are negligent as a matter of law.
So violating the statute is the negligence. It replaces the reasonable person test for that specific conduct.
In essence, yes. The unexcused violation of an applicable statute is often treated as negligence per se. It establishes duty and breach conclusively. Angela's notes mention Martin v. Herzog as supporting this. It's a shortcut for the plaintiff on the breach element.
But it's not automatic. There are conditions, right? The statute has to apply.
Absolutely critical conditions. For negligence per se to apply, the plaintiff has to show two things. First, that they are part of the class of persons the statute was designed to protect. Second, that the harm they suffered is the type of harm the statute was designed to prevent.
Can you give an example?
Sure. Say a law requires fences around swimming pools to prevent children from drowning. If a child sneaks in and drowns, the owner violates the statute. The child is in the protected class, children, and drowning is the type of harm the statute aimed to prevent. So negligence per se likely applies.
But if, say, an adult delivery driver tripped over a toy left near the unfenced pool, would negligence per se apply from the fence statute?
Probably not. The statute wasn't primarily designed to protect adult delivery drivers from tripping hazards. It was about preventing kids from drowning. So the driver would have to prove negligence using the regular reasonable person standard, not negligence per se based on the fence statute.
Okay. The class of person and type of harm tests are key filters. What about excuses? Can you violate a statute but still avoid negligence per se if you have a good excuse?
Yes, the violation generally must be unexcused, but the bar for excuses is quite high.
What isn't a valid excuse? Angela's notes mention some things.
Right. Things like just disagreeing with the law, being ignorant of the law, I didn't know that was the speed limit, or claiming everyone else does it, customary violation. Those are generally not valid excuses according to the restatement mentioned in the notes.
So what might be an excuse? The notes had that Lynn v. Murray scenario.
Yeah, that was interesting. Car stalled in fog because it hit an unexpected boulder on the road, violating a no stopping on roadway statute. The question was whether the sudden, unforeseen emergency caused by the boulder could excuse the violation.
So things like sudden emergencies not of the driver's own making, or maybe if compliance would have been more dangerous than violation.
Those are the kinds of things courts might consider as valid excuses. If compliance was impossible or demonstrably riskier due to circumstances beyond the defendant's control. If excused, the statutory violation doesn't automatically establish negligence, and you'd fall back to the regular reasonable person standard.
Okay, so an unexcused violation of an applicable statute equals negligence per se. What about the flip side? What if you comply with the statute? Does that automatically mean you weren't negligent?
No, definitely not. Compliance with the statute is relevant evidence that you are acting carefully, but it's not conclusive proof of non-negligence.
I know.
Because the reasonable person standard might require more than the statutory minimum in certain circumstances. Angela's notes make this point clearly. The negligence standard of an ordinarily prudent person may be a higher standard than the standard of care followed by a particular community or industry, or even a statute.
Like your example earlier, driving the speed limit in a blizzard might comply with the speed limit statute, but it's probably not what a reasonably prudent person would do. It could still be negligent.
Yep, exactly. Compliance is evidence of due care, but it doesn't guarantee you weren't negligent if the circumstances demanded greater caution. It's different from industry custom, too, which Angela's notes distinguish. Custom is just evidence of what's done. It doesn't set the legal standard like negligence per se can. Failure to follow a custom might show breach of the reasonable person standard, but it's not negligence per se.
Wow, okay. That's a really thorough breakdown of duty of care. We've covered the general standard, the reasonable person, foreseeability with Paul's graph, all those special duties for kids, professionals, landowners.
Rescuers, prenatal injuries, and finally how statutes can set the standard through negligence per se. It really is the essential starting point for any negligence analysis. Understanding who owes a duty, to whom, and under what standard is step one.
Absolutely. And we really have to give a huge thank you again to Angela. Her torts notes and outlines are just fantastic and made putting this all together possible. Really great stuff.
Definitely. Her work is the foundation here. Now, before we wrap up, we have our usual important housekeeping items and disclaimers. Got to do these.
Right, you are. Okay, first off, please remember, Angela is a student, just like many of you listening. She hasn't passed the bar yet. She's not a licensed attorney or a legal expert.
Yeah, very important. Second, flowing from that, neither Angela nor this podcast is giving legal advice. Nothing we've said should be taken as legal advice for any specific situation you might be facing.
Definitely consult a qualified attorney for actual legal advice.
Mm-hmm.
Third, remember that AI that's us isn't a substitute for doing the hard work of studying the law yourself.
Mm-hmm. This podcast should be a supplement, maybe help clarify things, but it can't be your only study tool for the bar or for understanding these deep legal concepts.
Fourth, a little honesty about us AI.
Yeah.
We're not perfect. Sometimes we might make mistakes or misinterpret something. Angela does her best to review and correct things, but, glitches can happen.
True. And finally, the most practical point. If you are listening to this while driving, please be safe on the road. Your focus needs to be on driving.
Seriously. We don't want you to cause a tort while listening to torts.
Yeah, don't do that. Safety first.
Okay, just a reminder on how to reach Angela again. For podcast-related stuff, it's podcast@studyforthebarinyourcar.com.
And for potential freelance law clerk work, research, writing, etc., it's hello@legalwriterandlawclerk.com.
All right, I think that covers it. Time for our traditional sign-off. Oh, wait, the joke. Nearly forgot. You got one about duty of care.
Okay, let me see. Why did the reasonable person cross the road?
Uh-oh. I don't know why.
Because under the circumstances, exercising due care, considering foreseeable traffic patterns and potential pedestrian hazards, it was determined to be the most prudent course of action to reach the objective on the opposite side.
Oh, boy. That's meticulously dutiful.
Well, I tried.
Okay, then. On that note, this is Maude and Claude, your AI bots signing off.
Thanks for listening. Bye.